lunch break in the matter of the state of Georgia versus Christopher Wolfenbarger, case number 24SC004201. I'll note that Mr. Wolfenbarger is in the courtroom, and before we adjourned for lunch, I had asked Mr. McDermott if you'd had a chance to discuss with your client the choice to testify or not testify, and if a decision had been made in that regard, so that I could go ahead and have a conversation with Mr. Wolfenbarger about that. And so you requested at the time to wait and let you have further conversations with your client during lunch. And so have you had a chance to have those conversations, Mr. McDermott?
Yes, ma'am.
Okay. So is now acceptable to you for me to inquire with Mr. Wolfenbarger?
Yes.
Okay. Mr. Wolfenbarger, so I'll tell you like I tell witnesses. I'm fixing to ask you a series of questions, and when you answer, I'm going to need you to answer out loud so that the court reporter can take down your response. Do you understand, sir?
I do.
Okay. So, Mr. Wolfenbarger, do you understand that you have a right to testify in this trial, and that if you want to testify, that nobody can prevent you from testifying?
I do.
Okay. And do you understand that nobody can make you testify? That is, you have a right to not testify if you don't want to.
Yes, ma'am.
Okay. And do you understand, sir, that you, not your lawyers, are the person who makes the decision whether you will testify or not testify?
Yes.
And do you also understand, sir, that if you do not testify, then upon request by you or your counsel, that I will instruct the jury that your decision not to testify cannot be used against you in their deliberations?
Okay.
Okay? So you do understand that?
I do.
Okay. And do you understand that if you choose to testify, you won't just get asked questions by your own lawyers, you will also be subject to cross-examination by the state's lawyers? Do you understand that, sir?
I do.
Okay. Now, I don't want to know what you've discussed with your attorneys, but have you had a chance to discuss with your attorney the decision whether you will testify or not testify?
I have.
Do you need any more time to talk to your lawyers about that decision?
No, ma'am.
Okay. Having had an opportunity to talk with your attorneys about that decision, do you wish to testify in this case, or do you not wish to testify?
I do not.
You do not wish to testify. Is that correct?
That's correct.
Okay. So thank you, Mr. Wolfenbarger. Based on your responses to my questions and your representations regarding having had ample time to discuss that issue with your attorneys, I find that Mr. Wolfenbarger has made a decision to not testify, and that decision has been made with an understanding of his rights, and that decision is knowing, voluntary, and intelligent. The second issue I wanted to take up with y'all is, it might not matter at this late hour, but my understanding is that the Sheriff's Department has now acknowledged that warrant and said they are taking care of it. So I don't know what that means, but it is what it is.
That's what the deputies told me as well, and it's unclear how we can kind of monitor it, but I know in the past when I try to call the warrant division, they rarely give me much information, but I take their word for it. They're working on it, and we'll either stay in touch with you or maybe the DA's office, and I can try calling the warrant division. I just know they're usually very reluctant to give information on the phone. So.
Okay, thank you. Now, the other thing I wanted to take up, I don't know how long it might take and where we are in terms of how much more time we might need with the jury today before we would be ready to for the case to be done. But we do still need to revisit the matter of the motions that the defense wanted to put on the record in terms of any motions at the close of the state's case. As we put on the record earlier, in an effort to be efficient with the jury, we went ahead and reserved your opportunity to raise those objections or those motions after we went ahead and proceeded with the state resting in front of the jury, and then y'all going forward with some witnesses that you had.
Yes.
Okay.
At this time, in light of the state's having rested its case, we've moved the court for a directed verdict of not guilty on both counts. On malice murder, the state has not given any evidence of a cause of death. They have not shown any evidence that Christopher caused Melissa's death. They've not shown any evidence that she died unlawfully. On felony murder, they've not given any evidence that an aggravated assault occurred. They've not given any evidence that an assault occurred. They've certainly not given any evidence that it occurred with an object that could result in serious bodily injury. And they've certainly not also given any evidence that an aggravated assault occurred that caused her death, and they've not proved the cause of death. In neither case have they proved an intent to carry out either an aggravated assault or a murder with malice aforethought. In this case, Your Honor, is the evidence of guilt is only circumstantial, and the court must rule out every reasonable hypothesis that would support his innocence. They have not ruled out the fact that other people, including the victim's parents, including the victim's uncle, Martin Eric Jackson, including any number of random people in the area, could have carried this out. There are a number of reasonable hypotheses, and we've given evidence for some of them. And the court is authorized to apply that standard in granting a directed verdict. Just a second, Your Honor, please.
Sure.
The state has given some evidence from which, from what we've talked about with prior difficulties regarding the incidents of alleged domestic abuse that occurred in July of '98 and at some undetermined time before that. But when you're considering what a reasonable juror, well, I think your jury instructions covered as well, as far as what a reasonable juror would be allowed to consider as toward the elements of the crime. They cannot consider or infer character. They may not infer from those things that he had the character to commit other such crimes or wrongs later. In other words, they can't use that as propensity evidence. So they can't say, well, he did this, he may have hit her on one other occasion, so he must have done it later, and therefore that fulfills one of the elements of the crime. They can't do that, and this court can't consider that. And as far as prior difficulties are concerned, the finder of fact is only allowed to use that to consider a state of feeling between the parties. So I would say there's abundant lack of evidence in this case of intent and of the elements of the crime, and so we would request the court grant directed verdict at this time.
Thank you, Mr. McDermott. Who will I hear from for the state?
Me, Judge.
Mr. Fossett?
Yes.
Your response?
Your Honor, I would cite two cases. There's a, then my computer goes, one second. Your Honor, I would cite two cases as authority for the court at the basis decision on. The first case is Odom versus Hughes. That is a Georgia Supreme Court case, 293 Georgia 447, 2013. Second case is Miller versus Lynch, 351 Georgia Appellate, 361, 2019 case. It ultimately speaks to the decision before the court when there's a conflict and when there is no conflict in the evidence that's been presented by the state. Miller states the trial court may direct a verdict only if there is no conflict in the evidence as to any material issue, and the evidence introduced with all reasonable deductions therefrom shall demand a particular verdict. Where any evidence, even slight evidence, supports the opposing party's case, the directed verdict is improper. So first, the state is not required to prove evidence of motive, but the jury is authorized to consider evidence of motive. In this case, I would cite evidence of three different potential motives for this defendant to murder Melissa Wolfenbarger. First was the pending state court case from the July 1998 incident. There was a battery, and even though Melissa wrote an affidavit saying that she no longer wanted to pursue the TPO, we know from the March 29th, 1999 date that that criminal case was still pending. I think the fact that that case was still pending and that Melissa was murdered and was unavailable to attend, her head being found a month after that case was dismissed when they couldn't locate her, I think the fact that there was a pending case, the jury can consider that as possible motive. I think that the fact that this defendant was aware that Melissa Wolfenbarger was seeing an individual he referred to as Mike, we heard testimony from and confirmed and corroborated that. The fact that she was having an affair is another form of motive, possible motive for this defendant to murder Melissa Wolfenbarger. And we also know from Melissa's mother, the letters, and this defendant's own mouth that Melissa planned on leaving this defendant. All three of those are independent, separate, possible motives for this jury to consider as reasons why this defendant would want to have Melissa Wolfenbarger murdered. There are prior difficulties, and those prior difficulties further corroborate the battery that occurred on July 1998. There are three instances of the prior difficulties. The first in the beginning of the year, I believe it was February or March of 1998, where Carl Patton describes seeing marks around the neck of Melissa Wolfenbarger. Vividly describes that. As does the officer Marlon Sutton, describes the events that took place on July of 1998 when he, according to his report, observed bruises and abrasions on the person of Melissa Wolfenbarger. And then we have Thomas Dixon at the end of December 1998, which he's relaying information about the continual abuse that Melissa endured during that period, during that year, and also, again, how she planned on leaving him. I would say that from the testimony of the medical examiner's office, medical examiner, Dr. Terry in particular, her testimony was that she does not, in her expert opinion, believe that Melissa Wolfenbarger died of natural causes. That is from the circumstances of the facts that she reviewed, the fact that there were tool marks on the person, the bones of Melissa Wolfenbarger, on the neck, on the limbs, on the femur, the fact that the bags appeared to be situated to where she was, in her opinion, murdered at a different location, that those bags were placed there very recently to the time that they were located. Because of the rip in the bag, she isn't able to tell the time of death. You know that the head had not been outside of that bag for more than a day because there were no maggots, there were no insect activity. The doctor couldn't say whether or not the remains had been refrigerated and dropped off. That was a possibility. She also couldn't say, she couldn't say whether or not Melissa had been strangled because the parts of her neck were missing for her to make that determination. She couldn't say if she had been strangled. She couldn't say if she had been choked, stabbed, shot, or a number of other different manners of death were just not available for that determination because of what was missing. And I don't believe that the defendant should be able to benefit from how well he was able to dispose of her body. The statement from Dr. Cherry is that the circumstances lead her to no other conclusion, that it's highly likely that she died of homicidal violence. And I think that that in and of itself are facts sufficient enough that the jury should decide this case. I would ask that the court deny the defendant's motion.
So I agree with you absolutely regarding the murder charge, that there is evidence from which there's evidence in the record that would create issues for a jury regarding the fact that homicide occurred and the fact that Mr. Wolfenbarger may or may not have caused that homicide, which are issues for the jury. So I'm going to deny your motion on the count one for murder. I think for largely the same reasons I should refrain from granting a directed verdict on the felony murder, but I mean, candidly, I do have some concerns about the fact that even if there are clearly facts, the circumstances of her being found, right, that would support an inference, right, a reasonable inference if the jury decides to make that inference that the cause of her death was homicidal in nature. There's not any facts from which we can determine that any sort of weapon was used against her in any offensive manner. So how do I reconcile that?
Well, so it is not required for it to be a weapon. A per se weapon. So it's not required that the weapon be per se like a gun. Gun's per se weapon is by statute, but any object that has a possibility of causing serious violent injury.
Right, but there's no evidence of that. That's my point. I can infer that she was killed by homicide because of, for example, a jury could infer that from the circumstances of how she was found and how her body was dismembered and disposed of. But can you also rationally infer that she must have been assaulted with an object which, when used in the manner in which it was used, is likely to result in serious physical injury or death?
Yes, you can.
Okay.
And the reason why is because if she did not die of natural causes, there is the inference that there is an intentional act by the part of this defendant to cause her death, whether that is poisoning. That would be a substance that would cause serious violent injury. The aggravated assault could be the poison itself. If it was his hands around her neck and strangling her, the hands would be an object. We typically charge fists, feet, knees, elbows. All of those objects could be offensive weapons depending on how they're used. And it could be something that is man-made, like a gun, like a knife, like a belt or rope. And the point of the charging and the way the indictment is charged is because it is because there aren't parts of her that would allow for a determination, like the torso, for instance, like the neck structure. We cannot, with any degree of medical certainty, narrow down the limitless possibilities of objects that could have been used to kill Melissa Wolfenbarger. That's why, because of the circumstances of this case, dictate that the indictment be charged in a way to allow the jury to consider all of those possibilities. And so the court is going to instruct the jury.
Well, I mean, not necessarily. The DA could have elected to just charge murder, because either you can or can't prove murder. They didn't have to charge felony murder. I mean, you said we had to allege it the way we did. That's if you chose to allege felony murder, right?
Right. Having made that decision to charge felony murder, I think that the intent was to give the jury the ability to consider all the reasonable possibilities of objects that could have been used to commit this serious violent injury on the person of Melissa Wolfenbarger. And I'm saying it's serious violent injury because it wasn't a natural death. The circumstances create really the only reasonable inference is that this was a homicide. And so I think if...
Yeah, and don't disagree with you that maybe the inference is that it was a homicide. The question is there a reasonable inference that it was an aggravated assault that caused a homicide?
And I guess what I'm saying is it is impossible for her to have been murdered with an intentional act.
Without having also had an aggravated assault.
That is correct. That's correct. I don't see a scenario where that's possible. That's why I mentioned poison. Any object that would cause the death of Melissa Wolfenbarger with an intentional act would fit a category of an offensive weapon.
Okay. Thank you. Mr. McDermott, your response, sir?
What I hear the state saying is we can't eliminate every other reasonable possibility. And in the circumstantial only case, that's the standard by which it gets judged. It has to be. You're about to read jury instructions to the jury that says if the state has not excluded every other reasonable hypothesis.
Right, but that's a decision for the jury, not for me necessarily.
No, not only. There are cases that say that standard can be used during a directed verdict. Wood v. State, more recent one, I don't know the number here, if you want to look at it. Stack-Thorpe v. State, that was a 2004 case. It was a negative case, but they upheld the same standard, that you may use that on a directed verdict. And what I hear the state arguing is they're basically confessing to you, we have not eliminated every reasonable hypothesis. We can't tell you if it was poisoning, which, by the way, is not aggravated assault by a deadly weapon. It's a whole different category that they didn't charge. And I was going to say, and the same with strangulation. It is a separate statute under the aggravated assault statute. They didn't charge that. They charged specifically offensive weapon.
Setting aside the somewhat nebulous understanding that we all have because of the circumstances of how Melissa's body was found, am I wrong that the state is allowed to prove facts that would demonstrate in any way that it might have occurred? I mean, I understand your position is they haven't offered any facts about how it might have occurred, but there are different ways that someone can be assaulted in an aggravated manner, and aren't they allowed to offer facts that would prove any way that might constitute that under the statute?
Well, I mean, they can offer whatever they want as long as the court allows it. But as far as proving what they've charged in the indictment, they have to prove an offensive weapon.
Right.
Okay. It can't be by strangulation, can't be by poisoning, and they've not eliminated by the way that she died of a drug overdose in somebody's house and they panicked and tried to hide the body. There's a lot of possibilities they haven't tried to eliminate. And that's what I'm trying to say. This doesn't need to go before the jury. They don't have proof that an aggravated assault happened. They don't have proof of a deadly weapon. And they don't get to say, well, just let us have a smorgasbord before the jury. It's supposed to work in the opposite direction. If you charge something, you're supposed to be bound by that.
Okay. What, Mr. McDermott, you mentioned the Stack case. Can you give me that citation?
It's Stack-Thorpe, citation 270 Georgia App, 796.
Okay.
The other case is Wood v. State. It's a little older, 156 Georgia App, 810.
Thank you. As I've said, I'm going to deny the motion for directed verdict on the count 1 for murder. I'm going to look at the case law, and I'm not going to rule right now on the DV on the felony murder count, which is count 2 of the indictment.
Understood.
Do we have other witnesses that we'll hear from the defense?
I have one other witness here.
Okay.
I was trying to get in touch with another one who's just not going to be available, except maybe by Zoom. Did we discuss that? I'm trying to get him.
He did. He said he would.
And then the one we're trying to arrest.
Okay, so if I tell you that we're ready to resume for the afternoon and you have your one witness when they're done and you don't have another witness, are you ready to rest? What's going to happen then, sir?
I still want that other witness here. And I'm going to ask for a continuance if she's not here.
Okay. Obviously, does the state anticipate that there will be some rebuttal just from a timing perspective?
Yes, Your Honor.
Okay,
Minimal.
like how much? Like a whole day's worth or?
No, I would say at most an hour, hour and a half.
So we're still thinking, other than perhaps this witness and the request for a continuance to find that witness or deliver that witness here, we're still thinking that today we can get the evidence closed in this case. Is that still reasonable to you, subject to this witness?
Well, I mean, assuming my witness, yeah, subject to the availability of that witness. If she were here, I would probably need an hour, maybe 45 minutes with her.
Okay. Okay. So anything else we need to take up before we bring the jury back in?
Nothing from the state, Your Honor.
Nothing from us currently.
Okay. We're ready for the jury. Mr. McDermott, the defense may call its next
Joey
witness.
Wolfenbarger.
The defense calls.
I'm sorry, defense calls.
That's okay.
He switched sides.
Come on up, sir, and when you reach the witness stand, if you'll do me a favor before you sit down, turn around and face the deputy and raise your right hand. He'll swear you in.
You swear or affirm to the testimony that you're about to give, the whole truth, nothing but the truth, sir? You may have a seat.
Your Honor, I think I need to get Ms. German to admit me to the Zoom.
Ms. German or Mr. Freehoff or Ms. Johnson, can somebody admit Mr. McDermott to the Zoom?
I think I'm with the state and you think I'm the defendant.
Yes, exactly.
Please state and spell your name for the court, please.
Joseph Wolfenbarger. That's JOSEPH WOLFENBARGER.
And if you would, while you're testifying, if you'll just try to lean forward into that microphone to make sure that we can hear you, okay, sir? Thank you. Go ahead, Mr. McDermott.
Mr. Joey, do you know the defendant?
Yes,
How do you know him?
that's my father.
Okay. And do you know Melissa Wolfenbarger?
I've know of her.
Okay. And do you know Kathy Wolfenbarger?
Yes,
And how do you know her?
that's my grandmother.
And do you live with her?
Yes,
Okay. What do you do for a living?
mechanic for the most part.
Okay. Did you grow up with Kathy Wolfenbarger in her household?
Yes,
Okay. Do you remember at any time growing up, say around the early 2000s, that she took all the pictures of Melissa Wolfenbarger down from your house?
I don't really recall ever seeing pictures of her, like in the house.
Okay. Do you remember at some point in your life being told what happened to your mother?
Yes, more so at a young age.
And what were you told at a young age?
I mean, I would say I was at least about 4,
Okay.
5, maybe.
And what were you told about
Your
her?
Honor, I
It
am
was-
going to object to that. That would be hearsay.
Don't know exactly.
Sorry, I apologize, sir. When there's an objection, I have to just wait and not answer the question. Can y'all come here for a second, please? Mr. Wilson, the objection's overruled. Mr. McDermott, please go ahead.
I'm going to attempt to go back in, if I may.
Sure.
It might help to have the current day, right?
That would help. There's a new one every day.
Thursday, August 21st.
Yes, sir.
All right, we'll see if it works. Okay, I'll repeat the question. Do you remember what you were told happened to you?
That somebody had killed her, and that it's only so much you can tell a small child, but it was more so that it was done in a very horrific way.
Did you at some point move in with your father?
I mean, yes.
And about how old were you when that happened?
It was after high school. It was.
Okay.
Yeah, I can't recall the exact dates, but
Do you remember where you lived at the time?
yeah, same place he was found
Was it
in Griffin.
in Griffin? Okay. And did anyone else live with you at the time?
Yes,
And who were they?
my little brother, Alias, and it was mainly just us 3.
Did your sister live with you at any point?
No, that was before.
Did she come visit you at any point?
At what time are you referring?
This is afterwards.
Like,
Okay, let me try a different line. Do you remember at some point the defendant making a comment while watching a TV show that he knew how to dispose of a body by burying it under concrete or something to that effect?
It wasn't necessarily from a TV show. It was more so we were discussing about how Carl had gotten away with other murders, and we were talking about different scenarios. And my sister had walked in later on, kind of caught half of the conversation, and kind of been standoffish about the conversation.
Okay, so a couple questions just to clarify. The context of the discussion was Carl Patton's murders?
Right.
Okay. And at some point, Chrissy walked into the room and overheard the conversation?
Yes.
Okay. Your Honor, I'd like to share screen, please.
Okay, are you in?
I am in now. And what I want to share is previously discussed self-authenticating document. It's a nationally reported news article. I emailed it to you as you requested.
But y'all come in.
All right.
Just a moment. Thank you.
All right, the jury.
You can sit there. Yes. You just stay right there. Outside for just a moment, please. Thank you. But don't wander far, okay? Okay. Full disclosure, I did read the article at the time to assess that assertion. Mr. Fawcett, what is the state? Or Mr. Wilson, I guess technically it's his witness. What is your position? I don't really care. Let me clarify for my record. I don't really care who argues.
I sense that, Your Honor. Your Honor, that article is, we don't have any further, I agree that it's self-authenticating, but it's an article about facts of this case allegedly told by someone.
Well, let me.
That makes it for the truth of the matter asserted.
Well, forgive me for interrupting you. Mr. McDermott, what is the purpose of offering this article anyway?
Thank you for asking. The relevance of this article is that there was an audio played, an audio interview of Christopher in 2021 in his home. At one point in that interview, he's asking questions back and forth with Detective, I believe it was Sergeant Layton, and he said something about Melissa's body being found in bags. Layton jumps on that like a gotcha moment and says, "I never said they were in bags." That is a point the jury could hear and presume that Christopher was asserting knowledge about how she was disposed of that he didn't have prior to that. Christopher retorts in the video or in the audio, kind of just in passing, well, it was on the internet. And this article, that's why I had him stipulate to the date of that interview, was because this article was published in a national forum 3 days prior to that interview, and it would have been fresh in his mind. And so I think the jury, the defense certainly deserves to be able to put that before the jury to see that this was not only on the internet, it was in a prominent place, Dateline NBC, and as you can imagine, was certainly have been shared family to family and say, "Chris, do you know you're in this article," etc. I'm not going to elicit all that. The point is to just say, here's a nationally reputed article, and it would have been the source of his knowledge, or it could have been the source of his knowledge as to the bodies being in bags.
Tell me again who that conversation was. We're talking about the one in 2001?
No, 2021.
2021, thank you. And that was with Calhoun?
Shepherd and
Okay.
Layton.
Okay.
And it's the one where basically they get into this in passing. He mentions that their body was in bags. Speaking of something that happened much earlier, right? But they're like, "We never told you they were in bags."
Okay. Mr. Wilson?
Your Honor, I can't see how this is the proper witness to publish an article. I think that what he said himself is that he's offering it for the effect that it had upon Christopher Wolfenbarger. Not Joey Wolfenbarger, but Christopher Wolfenbarger. I think that needs to come from the defendant, Your Honor. This is using hearsay, and to say it's not for the truth of the matter asserted, unless he has personal knowledge of the facts behind it, it absolutely is offered for the truth of the matter asserted, not what effect it had on the defendant when you're asking another person to testify as to the effect that it had upon the defendant.
Okay, well,
by showing the article.
I wouldn't let him testify about what effect it had on his father.
I understand. Okay.
Go ahead.
Well, Your Honor, showing that article is tantamount to putting it into evidence. I think he can ask if he knows. He can ask what his personal knowledge is of articles on the. But to put that article on there and that somehow give it a self-authenticating extra level of authenticity, so to speak, and that's improper, Your Honor. I mean, because that's what they're doing. They're trying to bolster testimony by using a news article, which is not really how it should be done.
I also, so at the time I did review the article, and I looked at some case law, and the concern I have here is that there are ways to ask Joseph Wolfenbarger, were you aware that your mother had been found? Did you become aware that your mother had been found in bags sometime before 2021 or whatever? There are ways to establish that. There are even ways to establish that news articles that were widely available existed. But the only purpose, in fact, the only purpose to offer a news story like this, the only reason that it's self-authenticating is because the idea is that the facts in there are true and can be relied upon because they are in widely available, reputable publication. And what I need to pull up the case law that I was looking at because that was like a week and a half ago. I was looking at it like a week and a half ago, but ultimately my concern is that this is going to confuse things because it is a long article with lots of detail, some of which may or may not be in front of the jury. And I would be worried about confusing the jury when really what I understand you to be talking about is what you're trying to establish is that the fact that Melissa was dismembered and found in bags was publicly available knowledge prior to 2021. And there are other ways to do that without injecting all of this narrative information that's been wrapped up in a pretty package by Dateline NBC.
Okay. A couple of things. I just want to backtrack to what you said about self-authenticating and the purpose of it being that the facts in there are true. That's not an authentication question.
I understand it's not an authentication question.
The self-authenticating just goes to, is the source what it claims to be?
I understand, but
We're not entering any true facts. Now, as far as the whole article coming in, I began this discussion several days ago with Mr. Fawcett. I shared with him the link, and I said I don't want to put the whole article in. I just want to have a screenshot of the one paragraph that says the body bags. And, of course, this discussion is drug in the course of trial. You know how things go. I haven't gotten a ruling back and all that stuff. So my intention is not to put all these facts before the jury. It's just that one, and that's why along with the link, I sent a screenshot of just the beginning of the article that has nothing more than introductory material and one paragraph that mentions the bags. That screenshot also has the date on there, so I can ask him what date was this published.
Well, that's why exactly why it shouldn't be let in, because he's using that to supplement questions that can be asked of this witness.
I'm sorry, say that again, Mr. Wilson?
Well, you know, he's using the date, for example, the date of the article. He can certainly, as the court has already said, he can ask questions. Are you aware of these articles? Are you aware of these things? Rather than putting in an article itself.
So if I understood your Honor, that you would have a problem with confusing the jury, I think providing just a short screenshot of only the relevant information solves the 403 problem.
I'm sorry, I'm trying to find my prior research, and for some reason, the Westlaw is not cooperating with me, so just give me a moment. Okay. Now I found it. So I want to take a look at that. Mr. McDermott, what were you saying, sir? I was trying to look at Westlaw and pull up my prior research.
My apologies for interrupting. I was just appending on to what we had discussed, that you had discussed the problem of confusing the jury with facts that may not be in evidence, and I think providing only the screenshot with the one paragraph and the relevant information solves that 403 problem, so there's no confusion.
Well, I mean, the screenshot that you've provided says that Mr. Wolfenbarger was arrested on August the 7th. It says he's currently in custody. It says, it tells a story about Christina when she was 3 years old, that I don't recall her testifying to. I mean, I'm looking at the screenshot that you attached to your email.
Yeah, I'm a little, don't remember those being on there. Can I approach, Your Honor?
Well, I'm going to share my screen so you can see what I'm talking about.
Okay.
So this
May
is...
have gotten an earlier version of the screenshot.
Okay, well, the email that you sent me at the end of our pretrial conference on
Oh, that's right, the update.
last Monday,
Yeah.
that's the screenshot that you sent me, and it has lots of information that is not in evidence and or inadmissible.
That is true. Can I just redact that and leave what's below?
So, again, I don't understand why you need this news article to establish the fact you're trying to establish, which is that at least as of May of, does that say 2001?
Yes,
Okay.
2021.
2021, because,
And so the point I keep trying to make is that this was published 3 days literally before they went down and interviewed him on this point.
I understand that, but also, couldn't you have established that with Calhoun or Shepard?
I didn't interview Shepard, and yeah, it could have been.
I just mean, there are
Theoretically.
other witnesses in the case who could, okay. Here's the, yes, sir.
I don't want to hold up the court any
Okay.
further. If you want to rule against it,
Okay.
so be it, and we'll move forward. But it's authentic.
No question it's
um,
authentic, but it still has to be relevant and non-prejudicial and
It is
not,
relevant, but it's prejudicial. I understand that.
and not hearsay or subject to an exception. And just because it can be authenticated doesn't make it not hearsay. And what I'm primarily concerned about is that it has minimal relevance for the concern. I think that the prejudicial nature of the facts that are contained in here, which are either not in evidence or would be subject to some sort of limit. I mean, like I said, I related the stuff that was there, but even if you were to limit further what it shows, what I think I understand is that the purpose of this article is simply to demonstrate that in 3 days before the police talked to Mr. Wolfenbarger in 2021, there was a news article that said that she was found in bags. And there are other better ways that are less inflammatory and prejudicial than this narrative that's been put together and made all shiny and pretty by Dateline NBC. Okay. Anything else that we need to, and just to be clear, I understand I didn't give you a ruling, but I need y'all to let me know again when you need a ruling, right? Like that was 2 weeks ago. So, or, so.
In all fairness, I definitely tried to make that happen.
Well, I mean, you sent me an email, I understand that, but I've asked any number of times what other matters the parties need me to take up, and at no point did somebody say, oh yeah, there's this news article I want to ask Joey Wolfenbarger about, and you haven't ruled on that, Judge. Nor, in fairness, did the state say, hey, Mr. McDermott wants to offer this news article that we object to. Nobody brought that to my attention, so I apologize that we had to do it on the fly with the jury stepping out, but there's a reason I asked 87 times, is there anything else that y'all want me to address before we do whatever we're doing?
Understood.
Okay, thank you. So are we ready for the jury to come back? Mr. Wilson?
Yes.
Mr. McDermott?
Let me ask one more question.
Yes.
I don't have any other questions for this witness except one. I was going to take a previously admitted exhibit, the weather reports, and see if he would be able to read that for the jury. It's perfectly common sense. Any average person should be able to do it. And the detective, it's to impeach the detective who sat there and hemmed and hawed and made a big deal about it.
Isn't that document in evidence?
Yes.
So the jury can see it,
Right.
can they not?
Yeah.
And if it's common sense, won't they be able to figure that out?
So you're saying no do it?
I mean, I just don't know any, I mean, other than that if it's common sense, your average person should be able to read it. But if I recall correctly, the detective struggled a little bit to read it too. And so I'm not sure I understand why Mr. Wolfenbarger, hang on. I'm not quite sure I understand why Mr. Wolfenbarger would be able to understand it and relate that either. Joey Wolfenbarger.
I think that's the point. I think the detective was being dishonest. And I think if an average Joe mechanic can read it, it would impeach the detective's credibility.
Mr. Wilson, that noise you just made is not an objection.
I understand, Your Honor. Your Honor, I do object to that. I don't think, I think it's been put into evidence. It's already been questioned about, and I think it's been, to have a witness read it when the jury can read it is cumulative, repetitive, and argumentative, Your Honor. So I think it's not I don't think it would be appropriate for him to do it with his witness in front. I mean, obviously the person he did cross is Detective Calhoun.
Okay. I feel like you've made that document's in evidence, and you can argue that to the jury, and you don't need to inquire with Mr. Wolfenbarger about it, Mr. McDermott.
Fair enough. So bring it back
Anything
in here.
else?
I will say no more questions.
Okay. Could you get Mr. Joseph Wolfenbarger back for me, sir? Thank you. Deputy, we're ready for the jury again. Obviously, once we get Mr. Wolfenbarger back on the stand. Thank you, sir. Sorry for that delay. Come on back. And you can just come on back and have a seat on the witness stand. And Deputy, now we're ready for the jury. Thank you all. Please be seated. Mr. McDermott, you may resume your examination.
Thank you, Your Honor. No further questions for this witness.
Thank you, sir. Mr. Wilson, questions for this witness?
Yes, thank you, Your Honor. Now, you were born on July 5th of 1996, isn't that right?
Yes, that's right.
So you would have been about 2.5 when your mother went missing, correct?
That sounds about right.
And you have no personal memory of that, correct?
Not of her, no.
So you have no memory at all of your mother?
I mean, no, like not like a living version of her, no. There's little bits here and there I can remember, like of the ceremony, but that was it really. I didn't really understand, who she was,
Yeah, because you were only 2.5 when it happened.
Right. I mean, but it was later on when the ceremony and whatnot.
Now you lived with your mother. Well, excuse me. You never lived with your mother.
No, not really, no.
Yes, you lived with Kathy Wolfenbarger, your grandma.
Right.
She wanted you to call her mom?
Not exactly. It was just more so it was easier that way.
So you did call her mom?
Yes.
Okay. And you never saw pictures of your mom at all while you were growing up?
I mean, I've seen some, but they wasn't like displayed all over. There was, the rare occasion that we would go through photo albums or whatnot, but, that's the only real time that I've seen them early on.
And those photo albums were located in the house, correct?
Yes.
Okay. And you were 4 when you were told that your mom had been murdered?
I would say that's about right. 4 or 5, somewhere around there.
And you were told by Kathy Wolfenbarger, correct?
Not really. I mean, it was more so of Rachel. Like she got more into detail with it.
Okay.
But, I mean,
And so you heard a bunch of details
yes.
when you were 4.
Yes.
And you never asked your dad about what happened, correct?
I mean, it'd always been a touchy subject for, talk about with anybody, it's not really.
Okay. So you never had conversations about your mom's death with your dad, haven't you?
I mean, bits and pieces,
But nothing extensive.
Right.
And that over the years?
Right.
Okay. And after high school, you moved in with your dad.
Yes.
And you haven't had conversations with him about it? Only bits and pieces, correct?
Correct.
And you were still living with him. You're still living at that address?
I mean, not at the moment, but, I was off and on for a while, shared 2 residents.
Who was the other residence was Kathy Wolfenbarger?
Yes.
May I just have a moment?
Sure.
You live, right now, you live with Kathy?
Yes.
Okay. And who is Rachel?
That was the woman he got with after my mom.
Okay. So you've talked about it with your dad's girl, kind of living.
Right. They were living together and they moved in across the street.
Okay.
You know.
One more moment.
Sure. Thank you.
What year were you born again?
96.
96. So when Melissa's remains, or when you went to the ceremony, you mentioned the ceremony a while ago, and you said you had just faint memories from the ceremony. And that would have been in 2003, correct?
Yes.
And so you would have been about 6 or 7 at that point. Would you have been 6?
Yeah, give or take, yes. About 6.
So you wouldn't have heard anything about your mother's, how she went missing until after that point, correct?
Yes.
Okay. And is your memory still fuzzy from all that stuff?
Right, right.
Okay.
Like I can remember like bits and pieces, like kind of where we were standing or whatnot, but you know, just
And so is it safe to say that the discussions you had with Rachel would have come after that point?
right.
Okay. No further questions.
Thank you. Anything else, Mr. Wilson?
Just very briefly.
Sure.
Now you have a full sister, correct?
Can you?
You have a full sister. You have a sister.
Yes.
And what's your age difference
10 months.
between you and Chrissy?
Yes. 10 months.
Okay. Nothing further.
Mr. McDermott?
I'm nothing further. You may be excused.
Thank you, sir. You can step down and you are excused as a witness. Mr. McDermott, defense may call its next witness.
So, may we approach, Your Honor?
Yes. Minutes. We're getting your steps in today. Thank you very much.
All right, so here.
Thank you. You may be seated. The jury's clear. Deputy, can you do me a favor and check on the status of efforts to locate that witness or bring that witness here, because that's the next witness they want.
I will have to go upstairs because I don't have the number.
Okay. I'm gonna, because it's time sensitive, is it okay? I'm gonna ask that we leave that deputy here and you go take care of that while I take up some other matters with these individuals.
He has to go.
So if he goes, then I can't take up these other matters with these lawyers because he's not here.
Yes, Your Honor.
Miss German, can you get another deputy in here? Because if you leave, then
I see my problem.
Thank you.
Your Honor,
Yes, sir.
I'm curious about the rebuttal. I just want to make sure the rebuttal rebuts something that occurred today, because we didn't have a case yesterday, so the rebuttal has to be something in response to something that happened today.
Obviously.
And I'm curious. I don't think they have to pre-clear it, but I guess I'm preemptively filing a motion that they don't get to just start putting up new witnesses or dealing with issues that came up yesterday or last week, or it has to be rebuttal of today, because we didn't have a case before
I
today.
think we all know that that's what rebuttal's supposed to be.
It is.
Okay. What, though, of our other witness? They're not here yet. Mr. McDermott or Mr. Samuel, can one of you tell me who that witness is? Because I'm having the deputy check. Now, by some miracle,
Someone is coming to believe.
thank you, sir. By some miracle, maybe he goes upstairs and finds out that that person is already in a sheriff's car and is on the way here from wherever it was that I saw that they were from, which was, yeah, far away. No, it was, I thought it was out the west side toward Alabama.
It's Covington.
It's Covington? Okay, so east side. Okay. But that's far. In any event, so let's say by some miracle that person is somehow going to be produced here today. But it's very likely that that person is not going to be produced here in any reasonable time to be testifying today. And so my understanding from you, Mr. McDermott, is that it would be that y'all would be moving for a continuance. Is that correct?
Yes, Your Honor.
Tell me who this witness is and why you believe that a continuance would be justified to allow that witness to testify.
So, one of the undercurrents in this trial has been the relationship between Melissa and Christopher's family, Melissa and her family. A huge part of that is this custody battle, and I think the jury's going to have to decide at some point. One side was pressuring her to do this, and one side she wanted to be with, or maybe there's some other complex dynamics. In my opening statement, I gave, basically said that the evidence is going to show that there's strong evidence of a very poor relationship between Melissa and her mother at the early stages of her life that ended up leading to her running away. Okay. The state has been able to counter that by presenting these evidence of these cards and the letter, et cetera, et cetera. Mm-hmm. But I have relied upon this witness to provide the evidence I need to sustain what I told the jury was going to show. And I think it's a relatively important piece of evidence to show that she did have a poor relationship with her mother. And so this witness was a next-door neighbor to the Wolfenbarger, or to the Pattons.
To the Pattons.
Sometime in the 80s up until maybe the early 90s. She was best friends with Melissa. She is going to testify that all the things I said in my opening, including some that are arguably worse, that they were locked in their rooms, they were not allowed to leave to get water. Melissa was not happy. Melissa began running away with her. Eventually, on at least one occasion, did drugs with her and got into some other things. And she's going to testify that the locking in the rooms specifically went on from about age 7 until about age 12, every day that she came over there, all day. And there's a considerable amount more of a backstory to that. So, and then at some point after the finding of the baby, Melissa started running away.
Well, that's in evidence. I mean, that part very clearly is in evidence. I've heard people discuss it multiple times, and not just through lawyer questions.
I don't need her to establish that point, but it does establish it in the context of the timeline of what she calls Melissa's neglect and abuse. She will also testify that there were times that at some point her mother would not allow her to have makeup. She had to use colored pencils on her eyes. She's going to testify that her mother would not give her feminine hygiene products, that she had to use socks for pads. And I think those are all relevant as far as illustrating the relationship and the feelings Melissa would have had to her mother. I cannot fulfill what I said in opening statement without this witness. And so I think for that reason alone, not to mention the extremity of what she's going to testify to, I think it warrants a continuance if we need to have it.
Do we have any information about why she's not here?
I do. So when I initially contacted her probably 2 weeks ago, I was actually shocked that I finally got through to her, and she was effusive to me. She was like, I want to tell my side of the story. I want to tell this. She's very clear she's not a fan of Chris, and she's not on his side in this trial. But that she said, I will show up and tell the truth. I said, well, would you testify? She said, for him, no, but I will tell the truth. And I said, if I subpoena you, will you come? She said, yes. And she, on a couple of occasions, kind of went silent as I was trying to communicate to her what days to be here. But she came back a couple evenings ago and told me that because I think it was her stepson died at the beginning of July, she's been dealing with depression and things like that, and that she just needed to spend a day or two in bed. But she texted with me. She sent me a bunch of pictures of Melissa and them growing up. She was very open about it. I shared with her that, if cost is a problem, we're allowed to reimburse you for certain things, travel, whatnot. And she said, oh, okay, fine. And it was clear to me at that point she was going to come. And then yesterday, she didn't come. And then I contacted her last night, and she gave me a hard, trying not to use the words she used, but it was basically
Not just no, but
I think she realized that what she has to testify to will help Chris in some way, and so now she's refusing to come. And I did not tell her I was going to send a deputy because I don't want her to run and hide somewhere. And that's the long and short of it. So the short story is that it was not until the day, or I think it was early this morning, that I got text from her saying I'm absolutely not coming, and variations of that.
okay. So realistically speaking, though, I mean, let's play this out logically. Are we confident that even if a deputy did go to her house and force her to come here, that she would willingly testify? I mean,
I fully expect she's going to be resistant, and I would ask to treat her as an adverse witness. I have our conversation recorded, and I've made a transcript of it. So I am prepared.
well, if she's refused to, well, she wasn't. I mean, she isn't available if she's refusing. But anyway, what are your thoughts, Ms. Hilton, or somebody from the state?
I'll just add, if the state will waive cross, we'll be happy playing portions of the audio.
That won't happen.
She said that won't happen.
Your Honor, we don't necessarily object to a continuance if this witness is under subpoena and can get here. So we're not opposed to the continuance, Your Honor. We would ask if we can have a copy, at this juncture, can we have a copy of the recording and the transcripts of this witness's interview so that we can prepare? So that's
It
what
was sent 2 days ago, Your Honor. They have the email.
You mean you emailed them the audio file?
Yes.
Thank you. Okay, so one other question that I had asked counsel at the bench, I mean, it's less than ideal, but if there is a chance, which I'm going to wait and see what I can hear from the state, from the sheriff's office about any progress that's been made to locate this person and go get her. But if there is rebuttal, is it possible we could just go ahead with rebuttal and come back to this witness if we can get her here later today?
I would not prefer that because I don't know what she's going to say, and my rebuttal witnesses may need to address what she's going to say, and so I wouldn't want to start any of my witnesses.
In fairness, Mr. Wolfenbarger did pretty much tell you what he was going to. I mean, it sounds as if the only knowledge that she could have if she knew Melissa when she was a kid is Melissa didn't get along with her parents and some specific facts about it.
But we never know what's actually going to come out on the stand. So we understand the recording, we understand what his proffer is, but I don't know what she's actually going to say, what's actually going to come before this jury. And so the state would prefer to have the defense finish their case, and then the state moves forward with rebuttal at the conclusion of their case.
Okay. Yes, Mr. McDermott.
Yes, Your Honor. Your patience is unlimited and admirable, and there's no reason they couldn't go ahead with the rebuttal witness, and if our witness is here or not, we can still hold her over to the next day. I mean, I'm saying we can still do the rebuttal if they want to.
Yeah, I think I know everything I need to know except for what effort, if any, has actually been made to go and find that person. So at this point, we're just going to have to let the jury cool their heels for a minute until I step off the bench so that Deputy Holt can go check, because for some reason there's not two departments that do that, right? Poor Miss Deputy Holt is stuck doing it himself, even though he's also got to be in here doing this part of the job. So in any event, I'm going to take a break for a moment so that Deputy Holt can step out and see what the answer is about this witness. And then I will come back and we will figure out what to do. I will tell you that I don't love the idea of a continuance, but if there's some reason to believe that she can be gone and gotten, and all I need to do is delay until perhaps in the morning, that's not unreasonable. But this case is going to the jury tomorrow. I mean, I just don't see a universe in which we can justify for what sounds to me like relatively narrow topic of inquiry for a witness, delaying this jury beyond having the case tomorrow. But I might consider a continuance tomorrow if there's some reason to believe that she might be gotten and delivered here and cooperative. So anyway, I'm going to step off. It's 3 o'clock. I'll come back and maybe